Good evening and welcome again to the subject of KB3 Business Law. I will continue from where we stopped yesterday, and we were discussing about the duties and responsibilities of directors in a company. I was explaining yesterday that certain acts of shareholders and directors may result in certain damages and other wrongful acts committed against the companies. Therefore, now I will address on the consequences of wrongful act of shareholders and directors. What amounts to a wrongful act or omission of a shareholder or a director is a question that I would like to pose at this stage, since an act or an omission of a shareholder or a director may create certain wrong towards a company, and their consequences will badly affect the company and its affairs. The effects of a wrongful decision or act or omission, including act of ultra vires, which I explained yesterday very specifically on the term ultra vires, a Latin term that means anyone who is acting either without authority or in excess of authority or in abuse of the authority, acting out of scope, amount to the lifting of the corporate veil, which is in fact a fundamental theory and concept in companies, that a company as a distinct and separate person from its shareholders and directors are covered with a corporate veil, that when such wrongful acts or omissions of shareholders or directors lead to the piercing or the lifting of the corporate veil, so that we could see who are really in fact in the company and who are responsible for being acted in ultra vires and thus committing a wrongful act. To determine those who are responsible for such conduct, the company does not hold any liability in that respect when a certain shareholder or a director has acted in ultra vires, and that would let the corporate veil being pierced or being lifted in order to identify the responsible party that has committed such wrongful act or omission in a manner detriment to the company's affairs. Now, I would like to further emphasize the piercing of the corporate veil. In this, much of clarification can be provided by considering the case of Guilford Motor Company versus Horn. It's another English case where Mr. E.B. Horn was the managing director of Guilford Motor Company Limited, where his contract of employment as a director, or rather the managing director, stipulated not to solicit customers of the company if he were to leave the employment. Now, there are similar clauses being enacted in contract of employment nowadays in various styles and ways, that an employee of a company shall not engage in a manner detriment to the company that he worked before. That would further make certain reservations that such obligation would continue even after leaving the employment, maybe for a year, 2 or 3 and so forth. So in this case, E.B. Horn, when he was fired from the company, he started his own business and undercut former employers' prices in competing with similar trade in the company that he just started. He also created a company by the name H.M. Horn and Company Limited of his own, keeping his wife and one Mr. Howard as sole shareholders, while engaging in providing spares and servicing of all models of Guilford vehicles, which was in fact very much similar to the affairs of his former employer, and solicited the customers of his former employer, Guilford Company. Now here, in order to see whether Horn has breached his duties towards the former company that he was bound to, the court lifted the veil, or rather the corporate veil, to find the involvement of Mr. Horn by purportedly inserting 2 different persons, that's his wife and Mr. Howard, as sole shareholders, inserting 2 different people likewise as shareholders, but running the company physically by himself. So in that case, Horn was really the person behind the scene, though his wife and one Mr. Howard had been included as the sole shareholders. So once you lift the corporate veil, there you would be able to find who are really involved in the management of this company that Horn had created in the name of H.M. Horn and Company Limited. So therefore, by piercing or lifting the corporate veil, the court could see that Horn has really breached the terms of his former employment, and thus breaching his commitments towards his former employer. So the lifting or the piercing of the corporate veil enabled the court to find out the real culprit behind this entire issue, where it competed with his former employer's business. Now a similar matter arose in the Hatnational Bank versus Jayawardena and others, the Sri Lankan case, where it was pronounced that although the independent personality of the company is distinctive from its directors and shareholders, in appropriate circumstances, courts have lifted the veil of incorporation. In particular, courts have been vigilant to allow the veil of incorporation to be used for some illegal and improper purposes or as device to defraud creditors. Sometimes there may be circumstances where certain directors or shareholders are really acting in a very illegal manner or to the detriment of a company, whereas finally the company has to suffer these kinds of wrongful acts played by the directors or the shareholders, and maybe all of them together in certain circumstances. Therefore, lifting or piercing of the corporate veil by the court is an important step in order to ascertain whether such wrongful acts have been really committed in personal capacity by the players behind a company. With that, I would also like to now express about the operation and mismanagement area. Now, operation and mismanagement can be taken use of when the directors of a company act in detriment or in prejudice to the company affairs, where the company falls into difficulties due to the conduct of such directors acting in a manner oppressive and as well as mismanaging the company affairs. Now, let me take these two separately, with the first one being the oppression. Under section 224, oppression means the affairs of the company are being conducted in a manner oppressive to any shareholders or shareholders, which means that the manner in which the directors or director act would affect that particular company's shareholders. Oppressive is generally termed as burdensome, unjustly harsh, tyrannical, causing discomfort by being excessive, intense, distressing or grievous, and etc. So the term oppressive has a wider scope of coverage, that it could include all these things that the directors are involved in the company or in the company's day-to-day management, thereby causing prejudice and damage to the company's shareholders. Now, next is what leads to mismanagement. Section 225 of the Companies Act states that when the affairs of the company are being conducted in a manner prejudicial to the interests of the company, or material change has taken place in the management or control of the company, whether by alteration in its board of directors, agents, secretaries, or in the constitution or control of the firm, or in the ownership of shares, and due to that, it is likely that the affairs of the company may be conducted in a manner prejudicial to the interest of the company. As a lawyer, I have handled these kinds of situations in courts where their shareholders had complained of acts of oppression and mismanagement against directors of certain companies. However, these two areas much often come together in a case where the shareholders rely upon the two provisions in the Company Act, section 224 and 225 in particular, and complain of acts of oppression or mismanagement against the directors who have acted in such prejudicial manner to the shareholders as well as to the company. In such circumstance, such shareholders or the company itself can seek the order of the court to bring the company's affairs back on track, thus declaring the acts of the directors being prejudicial to the company or to the shareholders or to both. And then in that circumstance, they can also move for damages for such acts that the directors have committed. And not only that, at outset, in the initial stage, these claimants or the plaintiffs or the petitioners, being the shareholders, could obtain injunctive relief to keep the directors aside without enabling them to further function as directors until the case is being heard finally by the court. I explained yesterday about the injunctions. That's either interim relief or a permanent relief that could be sought against these directors in these kinds of operation and mismanagement areas, that their continuance as directors could be withheld, and also that the company affairs could be alternatively handled in place until the final decision being taken by the court. Now, the most important thing is that who could make an application to court to prevent such circumstances? As I mentioned before, the shareholders have the right to make an application to the court against operation or mismanagement of directors. But however, only the shareholders holding a minimum of 5% of shares, which means the minority shareholder, could take up an action against such operation or mismanagement. If there are minority shareholders who are less than 5% of shareholding, then certain shareholders together, collectively, that represent the 5% minimum requirement, for the last 6 months as they were holding these shares, could make such application to the court seeking for injunctive relief as well as final relief against these directors who are involved in operation and mismanagement. So therefore, the most important requirement there for the claimant, plaintiff or the petitioner, these shareholders should at least hold, if the case is filed individually by one of the shareholders, then to have a minimum 5% of shareholding, or they collectively come together in the case with a minimum total of 5% shareholding. Now, what are the remedies available in such circumstance? I mentioned a while ago that the court may issue interim order preventing the directors from acting further in the company, as well as pending the final relief, regulating the conduct of company's affairs. Now, in seeking for an interim relief, such as an injunctive relief, one must show that there is a prima facie case against these directors. What really means by a prima facie case is that on the face of it, there is a good case against these directors to show that they have been acting in oppressive manner or in mismanaging the company affairs. And also, the facts must be true and straightforward, so that the court would be able to, at first instance, grant an injunctive relief so that the shareholders or the company could safeguard their shareholding or the company as a whole in whatever circumstance they complain to the court. And as a final relief, they can seek the court to regulate the company's affairs, thus removing or thus allowing the removal of these directors from running the day-to-day operation of the company. The other type of actions that can be brought against the directors as well as shareholders are the derivative actions. The difference between oppression and mismanagement and derivative actions is that oppressive and mismanagement actions can be brought either by the company or by the shareholders against the directors, whereas derivative actions can be brought against shareholders or directors by directors or shareholders who are representing the benefit and interest of the company. So, let me first of all explain what is a derivative action. A derivative action is a lawsuit brought by a shareholder or a director, as I mentioned, but they are bringing the derivative action to the court on behalf of the company. This is a distinct thing than any other type of a lawsuit, where such shareholder or a director complaining against another director or directors or shareholder or shareholders for the benefit of the company rather than for him or herself. So therefore, such a claimant or a plaintiff or a petitioner has to bring this action derivative on behalf of the company, and he should have the mandate to bring such an action to represent the company's interest, to enforce or defend a legal right or claim which the company had failed to do. Sometimes, for example, there are situations where certain shareholder or shareholders try to eliminate another shareholder or shareholders from a company. And in such a situation, if the act of that particular shareholder who tries to eliminate the other found to be prejudicial to the interest or benefit of the company, the shareholder affected by such act can take up the derivative action, and he has to explain and disclose to the court that such an act of that particular shareholder is against the company's goodwill, interest and benefit. So the action is primarily based on the interest that this affected shareholder has in order to protect the company. How can the court grant relief for an action be brought under the company's law in this case? Under section 234, an application should be made by the shareholder or the director affected or having interest in the company who has seen such prejudicial manner that a particular director or a shareholder is acting in the company against the company's goodwill. So such shareholder director, being the claimant, plaintiff or petitioner, should seek the relief from court on behalf of the company and in the name of the company, which means that the shareholder claimant should mention in the action that in the starting point, in the interest of the company and on behalf of the company, that the action is brought by Mr. ABC Pereira being a shareholder or a director of that particular company. Such shareholder or a director representing the company's interest on behalf of the company or even a subsidiary or even intervening in an ongoing proceeding can seek the leave of the court that should be first sought out. So, before obtaining or before proceeding with the derivative action, the claimant, plaintiff or the petitioner has to obtain the leave of the court, the consent of the court, satisfying the court that there is a matter at hand to be judged by the court, and in first instance to seek the leave to proceed further in establishing such conduct of a shareholder or director in a derivative action. This type of a lawsuit came from the common law of England in the case of Foss versus Harbottle in 1843. So, as early as 1843, such a matter came up to court where Richard Foss and Edward Starkey Turton were two minority shareholders in the Victoria Park Company. The company, Victoria Park, was to buy 100 acres of land near Manchester, and according to the report, enclosing and planting the same in an ornamental and park-like manner, and erecting houses thereon with attached gardens and pleasure grounds, and selling, letting or otherwise disposing thereof. The purpose of which these 180 acres to be bought by the company were so mentioned, and the claimants alleged that the property of the company had been misapplied and wasted, and various mortgages were given improperly over the company's property that is to be invested for those purposes that they had outlined. They asked that the guilty parties be held accountable to the company and that receiver be appointed to look into this matter. The court granted the relief, and this became the Foss versus Harbottle rule, what we generally call, that has given rise to a derivative action. And later, this Foss versus Harbottle rule became a statutory law provision that legislation was passed in line with this common law decision that later became to know the derivative action that shareholders or directors could seek from the court when certain directors or shareholders acting against the interest of a particular company. Next area is winding up, but I would also like now to go through some of the questions that had been given in the areas that we have already done. Now, yesterday we discussed about how to remove directors, what are the disqualifications of directors, And in line with that, I would like to take up this question where Senadira, a director of XY Private Limited, has not been attending the board meetings of the company on a regular basis. Now the shareholders of the company intend to remove him from the board of directors of the company. You are required to explain the manner in which director can be removed from office as per the provisions laid down in the Companies Act number 7 of 2007. Now what we have to identify here is that the conduct of Director Senadira that becomes prejudicial to the company affairs. The reason for his intended removal is based on the fact that he had not been regular at company's meetings, and therefore the company affairs could not be dealt properly when the directors are absent. So therefore, the shareholders, in doing so, must look at the provisions laid down in the Companies Act with regard to removal of a director. They can put forward such a resolution to remove this particular director on those definite grounds that he has committed against the company, and such resolution can either be taken in a general meeting or in a special meeting convened for the purposes of removing such director, and then a decision of the shareholders based on the Articles of Association that allow such removal, either by way of a simple majority or any other majority that is stated in the Articles of Association. They should take in accordance with those and decision to remove such a director. And thereafter, effect the company documents, especially informing the register of company of the removal of the director through the secretary of the company. And also, if further a new replacement is being made, such replacement also should be made to the register of companies. Question 1 here deals with the veil of incorporation separates the legal personality of the company from its shareholders and protects the shareholders from being held personally liable for the acts of the company. However, there have been instances where the courts have lifted this veil and held the shareholders liable for the acts of the company. state 5 instances where the courts have lifted this veil of incorporation. You have been asked to provide 5 instances in which the courts could lift the veil of incorporation. The statement, of course, is quite helpful for you to understand in what's the meaning of legal of the personality of company and of the shareholders, where by lifting or piercing of the veil of incorporation, the court will be able to find out who the perpetrator is and who are really innocent and have not committed anything wrong to the company. So therefore, the 5 instances could be that where a particular director has taken a decision contrary to the affairs of the company mentioned in the Articles of Association, or has acted in ultra vires, or has acted in a manner prejudicial to the company's interest and benefits, and has involved in certain private act that has, such as, for example, being a shareholder, like I said yesterday, that he has not disclosed certain businesses that have taken place in the company that has caused some prejudice to the company, as well as where the directors or shareholders have acted in a prejudicial manner or not doing justice to the companies, and thereby amounting to certain losses and damage causing to the company. And in these instances, the court can lift the corporate veil with the intention of protecting the company. Now let's look at this question. The directors of Unorthodox Private Limited, UPL, have proposed the following in relation to the company's registered address and company records. To change its registered office to the office of the chartered accountant of the company and to mention this in the register. To keep the company's certificate of incorporation at its factory premises. To keep only the last 5 years financial statements of the company at its registered office. To keep the minutes of all the shareholder meetings for the last 7 years at its registered office. To keep the minutes of all the director meetings, board meetings for the last 10 years at its registered office. You may assume that UPL has been in existence for more than 10 years. What you are required to do is to explain whether the proposals marked 1 to 5 above are in accordance with the provisions of the Companies Act. Support your answer with reference to the relevant section. Now, if I may just glance through these statements, the first one, if we take, to change its registered office to the office of the chartered accountant of the company, and to mention this in the register. In fact, the registration of the company requires that a registered address where the company's principal business is taking place should be the address that is registered. Now, there are certain companies that do not sometimes engage in active or physical business. Sometimes we call such companies are dormant companies, where they only exist on paper or in name. However, it is important that a company has its own distinct registered office, and therefore leaving the office, the chartered accountant of the company would make it impractical, and it's not allowed, because there might be clashing of the interests that to mention in the register, and therefore such a clause is not to be taken as effective. Second one, to keep the company's certificate of incorporation at its factory premises. Generally, the company's certificate of registration should be kept with the registered office of the company, unless the factory is also based in the registered office, registered premises. To keep only last 5 years financial statements of the company as its registered office. A company needs to maintain its financial statements in the registered office for at least the last 3 years, if it has been in existence for over that. To keep the minutes of all the shareholder meetings for the last 7 years at its registered office, which is all right. To keep the minutes of all the director meetings, board meetings for the last 10 years at its registered office, it's all right. This is to maintain that the company has been effectively running its businesses, but though such high requirements sometimes not needed, but in accordance with the Companies Act, there are these specific years that the company should maintain these records, and these can be found in the Companies Act with regard to such maintenance of the records. And yesterday I was telling that the directors could be found to have breached the Companies Act in certain circumstances that may even lead them disqualified from acting as directors in a circumstance or in a future circumstance, and these will be very helpful to ascertain whether the company has acted with due diligence, or rather the directors have acted in due diligence for the benefit of the company. Now let us talk about the winding up and the process of winding up. What is winding up? First of all, winding up is where a company's affairs fully come to a stage that the company would not exist thereafter upon being wound up, or that the company cease to exist. Winding up can take effect due to several reasons, and these reasons may vary on the circumstance that the shareholders voluntarily would like to close a certain company, or that the company cannot exist anymore due to financial and business viability, and that the company has not been able to meet up its debt, where the creditors of the company would wish to wind up such company, and so many reasons for such a winding up. As companies are distinct persons separate from its shareholders, as I have explained, the winding up process of a company should also be in accordance with the prescribed law, that is under the provisions laid down in the Companies Act. Therefore, closing a company is not easy as closing a sole proprietorship or a partnership or any other business. It has to follow the relevant criteria set out in the law, and sometimes even to obtain the permission of the court in order to put an end to such legal personality. In what circumstance a company could be wound up? Under section 270, the company has by special reason, a special resolution resolved that the company be wound up by the court, and this reason to bring up a special resolution may vary depending on the circumstances that I mentioned beforehand, and the reasons being numerous. For a company to take the decision through its shareholders to close the company affairs. The company does not commence its business within 1 year at inception from its incorporation, or it suspends its business for 1 year. In both these circumstances, a company can be wound up. That is, if a company does not operate its business during the first year after inception, or that at some point of time it suspends its activities for a 1 year period. It is a general duty under the law to annually send reports of the company's affairs, including the AGM report and other minutes and documents that the Register of Company requires. And through that, the Register of Company would be able to find out whether a certain company has been in existence for 1 year at its inception, after its inception, or it has suspended its activities for a 1 year period. If the number of members falls below the minimum number required by a company also, a company shall cease to exist, and this could be a reason to wind up a company. Yesterday I explained that a public company requires at least 1 shareholder, whereas a private company requires at least 2 shareholders. So therefore, when this minimum number is not met by a particular company, then the company shall cease to exist and be wound up. Another instances where a company can be wound up is where the company has no directors or not appointed the directors. It is very important that the directors are appointed at the initial stage by filling the names and the particular details in the registration documents, and thereby appointing such directors to look after the affairs or to manage the affairs of the company. So if such a duty has been failed to perform, by not having any single director in a company, that would lead to wind up. The other situation is that the company is unable to pay its debts, as I told before. If the company is unable to pay its debt, then moving forward would make a huge financial crisis for that distinct personality, and thereby the company shall be wound up in such a situation. Lastly, if the court is of the opinion, if the competent court that has the power to hear and determine company matters is of the opinion, once a particular petition has been forwarded or once the particular claim has been forwarded by an interested party in the company, the court is of the opinion that it is just and equitable to wind up the company, then the court can effect its ruling and wind up such company. So these things will be taken up separately in this lecture as we go on. So before that, I would like to emphasize who can wind up a company. Firstly, as I mentioned, a competent court can wind up a company. Secondly, the shareholders who created the company can also voluntarily wind up a company, and this is called shareholders voluntary winding up. And thirdly, the creditors to whom this company has debt or where the company owes these creditors some money, these creditors see that the company is unable to meet its debt, the creditors can voluntarily wind up, creditor or creditors can voluntarily wind up the company without letting the company run into severe hardships in terms of the finances. So let us first see how a court could wind up a company. Winding up by court. How should we apply to the court for such a winding up? According to section 272, an application should be made to the court seeking a winding up of a company, and this shall be by way of a petition. There is a special procedure in courts to file a petition, and especially in summary procedure, providing an affidavit of the presenter of the petition along with the petition is required, and such petition should be filed with the court by not less than 2 shareholders for a private company or 1 shareholder for a public company. So therefore, that minimum number of shareholders required as per the public or the private company must also be the minimum required number of petitioners in a court action for winding up by company, winding up by court. So there is no autonomous type of a winding up by court on its own. Obviously, the winding up by court should first start with the petition being presented by the least number of shareholders required, as I just mentioned. And the subject to the provisions of this section either the company or by any creditor or creditors, also can request the court by way of a petition to wind up a company. So, this creditor or creditors, including any contingent or prospective creditor or creditors, or even a contributory or contributories, which means that who have contributed by way of obtaining or subscribing shares to the company. Who have contributed or being a contributory to the company, even without holding shares, can petition the court for such a winding up, or by all or any of those parties jointly and separately. Now, let us again see one by one who are the parties that could petition the court for winding up. They include at least 2 shareholders in case of a private company, at least 1 shareholder with regard to a public company, or a creditor or creditors together of a company, including contingent or prospective creditor or creditors, and then a contributory to a company or contributories to a company, or all these people or some of them jointly petitioning the court for such a winding up. It could also be that some parties jointly make a winding up petition, and in the same matter another party separately petition the court to wind up the same company, so that the court can take up these matters together in ascertaining whether the company should be wound up. Now, who is a contributory can also be further explained as means every shareholder of the company and every other person liable to contribute, not being a shareholder but liable to contribute to the assets of the company in the event of its being wound up. And for the purposes of all proceedings for determining and all proceedings prior to the final determination of the persons who are to be deemed contributories, and includes any person alleged to be a contributory as well. So, that gives a wider scope to the term contributory, a party that has the power, the authority to petition the competent court seeking for a winding up of a company. Once a petition likewise has been made, the court may hear the matter as per section 273 and take up all the witnesses' evidence and testify the witnesses in order to ascertain whether this particular company should be wound up. On hearing a winding up petition, the court may dismiss it or adjourn the hearing conditionally or unconditionally, or make any interim order or any other order that it thinks fit. But the court shall not refuse to make a winding up order on the ground that the assets of the company have been mortgaged to an amount equal to or in excess of those assets, or that the company has no assets. So, therefore, the court has the power to make such orders, but however, it shall not refuse to make a winding up order on the ground that the assets of the company have been mortgaged to an amount equal to or in excess of those assets, or that the company has no assets. Thereafter, how does the winding up commence? Under section 277, where a resolution has been passed by the company for a voluntary winding up, where the balance sheets of the company are brought to zero, that the company does not have or does not owe anyone in a shareholder's voluntary winding up, or in the case of a creditor's winding up, that the company has certain debt to be paid. So, the resolution to be passed in such like manner, the winding up of the company shall be deemed to have commenced at the time of passing of the resolution at a meeting convened for the purpose, special purpose of winding up of this particular company. In any other case that does not fall within the voluntary winding up area, the winding up of a company by the court shall be deemed to commence at the time of presentation of the petition for the winding up in the court. So, the first category of voluntary winding up really start in the company's meeting, whereas a forced winding up, as we call the winding up by the court, commences with the petition being presented to the court for such winding up. What are the consequences upon winding up? Once a winding up order has been issued, the registrar shall make a minute thereof in his books relating to the company under section 278. And among the effects mentioned in 280, order for winding up a company shall operate in favor of all the creditors and of all the contributories of the company, as if made on the joint petition of a creditor and of a contributory. What is the procedure of winding up? There are certain steps to be followed. The first step being, an official receiver may be appointed, official receiver taking into account of all the assets, the liabilities and all kinds of things involved in the company, and he may be appointed on discretion of the court. So, the appointment of an official receiver is vested on court's action, and such official receiver, if any, attached to the court on generally for insolvency purposes, or if there is no such official receiver so attached to the court, such person as the minister in charge of the subject area of this company under whom the registrar of company falls, this minister may appoint as official receiver, may appoint a person or entity as official receiver to that court. Thereafter, once the receiver has been appointed, such receiver shall submit, having gone through all the particulars of the company and convening of meetings of the shareholders and so forth to find out actual situation of the company, shall submit a statement in the prescribed form of the affairs of the company, verified by his own affidavit that he has conducted in such manner and found these particulars, showing up the particulars of its assets, debts and liabilities, the names, residences and occupations of its creditors, and the securities held by them respectively, the dates when the securities were respectively given, and such further or other information as may be prescribed. He should forward such report within 14 days from the relevant date where a provisional liquidator is appointed, or within such extended time as the official receiver may be allowed by the court. Thereafter, the second step for the court is to appoint a liquidator or sometimes several liquidators. Sometimes when the court feels that one liquidator can handle the matter, one liquidator may be appointed, or otherwise, if depending on the company's magnitude, the number may increase. The liquidator or the liquidator so appointed shall take into his custody or under his control all the property and things in action to which the company is or appear to be entitled. So, the liquidator shall take into his custody all what is relevant for him, including the minute books, the respective accounts and other assets of the company, and shall be the custodian of all those things and act in a very fiduciary manner that he would not breach the trust of the court. The third step would be that where a company is being wound up by the court may, on the application of the liquidator by the court order, direct that all or any part of the property of whatever description belonging to the company or held by trustees on its behalf shall vest in the liquidator by his official name as liquidator, not as Mr. X, but in his official name as the liquidator so appointed for the winding up process of this particular company. So, the next step is that as soon as, maybe after making a winding up order by the company, the court shall settle a list of contributories. Now, when I say here that a winding up order is the initial step towards the entire closing process. It all ends finally with the dissolution of the company. So, therefore, the winding up process is the initial process that the court takes up. The court shall settle a list of contributories with power to rectify the share register in all cases where rectification is required by pursuance of this act, and shall cause the assets of the company to be collected and applied in discharge of its liabilities. And the fifth step would be that the court may at any time after making a winding up order, make an order on any contributory for the time being on the list of contributories to pay in the manner directed by the order any money due from him or from estate of the person whom he represents to the company, exclusive of any money payable by him or such estate by virtue of any call of shares in pursuance of this act. Thereafter, the court may order any contributory, purchaser or other person from whom money is due to the company to pay the amount due into a specified bank or any branch thereof to the account of the liquidators. Now, the use of the term contributory comes when a case is being filed for winding up. The shareholders do not qualify thereafter as a shareholder. They qualify in the winding up process as a contributory who is expected to contribute towards the company's winding up process and thereafter to the company's remaining assets or liabilities. Next step would be that where the official receiver becomes the liquidator of a company, I beg your pardon, the sixth step, the court may order any contributory purchaser, other person from whom the money is due to the company, to pay the amount due into specified bank or branch thereof to the account of the liquidator or the liquidators. The account maintained in the liquidator's official name. So, a bank account is open in the name of the liquidator's official title being the liquidator for the liquidation and winding up of this particular company. Where the official receiver becomes the liquidator, in certain circumstances, the official receiver may become the liquidator as well. So, in that case, whether provisionally or otherwise, if he becomes the liquidator, he may be satisfied that the nature of estate or business of the company or the interest of the creditors or contributors generally require the appointment of a special manager in addition to the receiver who has become the liquidator of the estate. A special manager be appointed of the estate or business of the company other than himself, so that the special manager could deal with the rest of the matters of managing the final affairs of taking up all the assets and other liabilities and running up to the time of dissolution upon finalization of the accounts of the company. Thereafter, the court may, in the event of the assets being insufficient in case to satisfy the liabilities, where the company has a debt or debts, make an order as to the payment out of the assets of the costs, charges and expenses incurred in the winding up that are payable to the receiver, liquidator, manager, so forth. Where the affairs of a company have been completely wound up by the court shall, where the liquidator makes an application in that behalf, make an order that the company be finally dissolved. Once all these affairs have been properly executed by the liquidator, then upon submission of the report by the liquidator as to the finalization of everything, the court make an order that the company be dissolved finally from the date of such order, and that would be the time, the exact date that the company shall be dissolved. So, we will thereafter go into more details of this winding up process, as well as discuss some important questions in the relevant sections that we dealt with in tomorrow's lecture. And for today, I say goodbye. Thank you for listening, and let's meet each other tomorrow in our presentation and lecture on KB3 business law. Thank you very much.